today's episode of May the Record Reflect.
There is a way to just present facts that appears to be just an objective presentation of facts, but have been skillfully and artfully arranged to cause the mind of the viewer to draw a conclusion from those facts. But you want them to feel like they are just observing. So that's the sort of the art of the storyteller in court.
That was David Mann, and this is May the Record Reflect. Hello and welcome to the monthly podcast of the National Institute for Trial Advocacy. I'm your host, Marcy Mangan, and in today's episode, I'm talking to legal story specialist David Mann. David works with trial lawyers on case story construction and persuasive presentation techniques. He earned his stripes in storytelling in theater, having decades of experience as an actor, director, and playwright. Now he uses his craft to help lawyers turn case facts into an engaging story with simple and effective messaging for trial. With this storytelling focus, lawyers find they're also much better prepared for motion practice and mediation in the months before trial. David is an adjunct faculty member at Loyola School of Law in Chicago and a program director at NITA. His presentations before state bar associations, international law societies, federal agencies, legal nonprofits, and law firms both large and small have given thousands of trial lawyers the persuasive tools they need to tell the story of their client's case. Today, David Mann returns to May the Record Reflect with valuable insight on how defense lawyers can overcome some of the hurdles that are inherent to telling their client's story. Here's our interview. So my guest today is someone we've had before, and it's David Mann, and I am so thrilled to have you back, David. Welcome.
It's great to be here. Thanks, Marcy.
Well, I think it's always fun to talk to writers and communication specialists since that's what I do myself. And today we're going to be talking about storytelling for the defense lawyer. And I know that you work in that exact space. You work with storytelling for lawyers. Can you tell us a bit about what you do, both for NITA and as a private consultant?
Yeah, sure. So I started out working with storytelling for lawyers based on my background working in the arts, working in theater. I'm not a lawyer myself, and I also don't try to get lawyers to be actors, but there is a story that needs to be told to a jury in litigation that if it comes across like fiction, even though of course it's based on fact, they will just understand it better. And it will resonate with them. So in other words, they want to make a decision as well as adding up, if they're critical thinking, that this is the correct decision to make. So usually lawyers are so focused on the facts and the evidence and presenting that all accurately that the story of it sort of gets lost in the mix. I help them get it to reemerge out of the mix so that it can be shaped into something that can be told to a jury and have them feel like they just heard a story of this case rather than been presented with the evidence of the case.
And so I know that you work with all kinds of trial lawyers, both in your capacity as a NITA faculty member and then again, privately. And from what you've told me, David, from this wide range of exposure that you have, you've noticed recently that the landscape of what used to work really well for the defense, even just a few years ago, has radically changed. What exactly has changed for the defense? What are you hearing from the lawyers you work with?
I think that what I'm hearing a lot of and seeing in my consulting work on cases is that defense, I work almost entirely with civil cases. So decades of defense basically needing to present an airtight defense, and they're going to win much more often than the plaintiffs. That's been traditionally what has happened by just presenting correct evidence correctly and all that. What I'm hearing from them and seeing with my own eyes with juries and focus groups that I'm observing and being a part of those cases is that that's not necessarily happening so quickly anymore. And jurors are they're always swayed to some degree by emotion, but it seems to be even more important now that defense lawyers are matching the storytelling skills of plaintiffs rather than just coming in and saying, you know what, we've got an airtight defense, here it is. They need to also be good storytellers, and they are just beginning to see how important that is and how they are now losing where they used to win. We're seeing the nuclear verdict problem. So juries are awarding tens of millions and even hundreds of millions of dollars in cases that just a few years ago that would have been unheard of. And now it's getting to be more and more regular. So that's how high the stakes are for defense. And it really is a fairly recent development as far as I can tell from what the defense lawyers I've worked with have said.
And do you know what accounts for this change?
I don't know if anyone can actually say with credibility exactly why this has happened, but I would speculate that it's some of it on the verdict thing has to do with it being sort of a snowball effect. The jurors hear about huge verdicts in other cases, and it gets to be sort of normalized that those numbers are, what you're going to go for. And that's fine. Now, $50 million it's $50 million because they may have heard, maybe even unconsciously picked up on some other case with those kinds of numbers. I think jurors are also hearing numbers in the general culture because you're hearing about the budget and the economy and stuff like that in billions and trillions of dollars. They're always hearing numbers like this, that it gets to be that is normalized, and it's easy for a plaintiff's lawyer to go in and say, where it might have a few years ago been a $5 million case, suddenly it's a $25 million case. And why that changed, who knows? Anyone can speculate, but it's what is happening. And it's meaning that defense lawyers have a lot more on the line when they're in trial.
Yeah, the new reality is very high stakes. So let's dig into this. And I'll start out by saying that I don't want to come across as sounding crass, but one of the strong suits for a plaintiff is that by the very nature of being the injured party, the emotional side of their story is very easy to tell. It's just right there, it's baked in. And that is because they brought a case because they believe that in one way or another they have been wronged. And we all know what that's like, what those emotions feel like, and how easy they are to access. And that's kind of a problem for the defense, isn't it?
Absolutely, it's a problem. Yeah. I mean, the conventional story, we think of it, if I've heard it once, I've heard it a million times in trial advocacy programs all over the place that, lawyers, you got to tell a story. So of course I'm saying that, but there's a lot of ways to tell a story. And the conventional storytelling format is that there is a hero, a main character, who's up against some obstacle and eventually reaches success, we hope, or maybe in a movie may not reach success. But that's the structure that we're very used to. Well, that's an automatic fit for a plaintiff's case. It is
Yes.
usually one person that has been gravely injured by the actions of the defendant, according to their case, by the actions of the defendant, which may be a doctor or somebody, but also a hospital or a huge company behind them. So it's sort of this impersonal thing that is, from the plaintiff's point of view, the villain in the story. So it's really automatic for a jury to hook into that one character's struggle because they've seen that kind of thing play out a million times in movies. Defense has to come up then and tell their story, and it's a hard sell to say, no, really care about this hospital or this huge corporation because it's just like a person,
Yeah.
Believe me, early on I tried that and it doesn't work that well. It rings really hollow. And so, the objective of defense is to humanize their case, which can be done many ways, but that's the first step in getting to feel more like a story.
Okay, so you said that humanizing is part of the emotional, I guess you'd say, on ramp.
Hmm.
to create resonance and impact with jurors. What else do you have to say about how to get on that highway that you need to get onto?
Well, the way to humanize it is sort of where there's variety to that. And that depends on the case to some extent. So you might have a case where a doctor is being accused of malpractice, right?
Mhm.
Um, you can't necessarily go out there and say, "Hey, care about this doctor, you guys. He's really busy," and you can't do stuff like that because it's just not going to work. But what you can do is you can paint a picture of the doctor in the room on the day and the moment that the decision was made, the decision in question in this case. Because in a medical malpractice case, especially, just about other types of cases too, but especially in that, plaintiff is usually saying the doctor should have seen this and should have done this and should have seen this and should have done that. This big long timeline.
Mhm.
The benefit of hindsight, in other words, we knowing what we know now, how it turned out, where this patient died, doctors should have seen this stuff earlier. That's what's very, very important is for the defense to paint a picture of the doctor on the day of that decision so that we can say, this is a depiction, an illustration of what it would have been like to be that doctor on that day making this decision with the information that that doctor had at that time. That's a storytelling skill to do that. It's not as easy as just like listing off the decisions that were made on whatever dates. You have to like paint the picture of he was sitting there looking at this monitor over here and picked up this pad and looked at the chart and whatever, and the decision was made. So you make it an illustration with words, and that's one of the ways that it can become more human without trying to like pull on the heartstrings and make this big emotional appeal.
So you can't just stand there and defend yourself. You need to tell a story.
Exactly. Yeah. It's the default for defense is they know what the claims are, and we can always speculate on how the plaintiff is going to present those claims. And so it, of course, because the task at hand in a trial is for the plaintiff to present claims and the defense to defend those against those claims, that's automatically what defense lawyers want to do. Is they want to say, well, here's our defense against that and our defense against that and our defense, and they're kind of like anxious to get out there and start doing those defenses in an opening statement. And it can come across as, well, impersonal. First of all, it can come across as a lot of negative, and it can just get into the weeds too fast. It can easily get into the granular data and details of the case before the jury has really comprehended things enough, and it's like not finding the gear on a bike. Like it's just skipping around, and they can't quite lock into what you're trying to say. And that's a big mistake, in my opinion, where it's not a story at all. It's just defense.
So how do you avoid that?
Well, of course, the simple answer is tell them a story. And then
Right.
that's where I come in, because lots of lawyers have an intention to tell a story, but don't actually tell a story. Are thinking, hey, I'm telling a story, but really are just going through a timeline. So I will do things like, like I just said a minute ago, find scenes where things happen and draw them to the foreground. So we can say, put people in the room where things happen. I look for those kinds of things all the time. So they're in there. It's just a matter of how you word it and how you present it to make it feel like a story rather than feel like, a bullet point list.
And some of that's really easy to do because we've all gone to the doctor. We've had that same experience, and you can just kind of latch on to what that feels like and know that that's going to land with jurors.
Yeah, and there's other types of cases that sometimes I will work on cases where what's in dispute is whether the plaintiff would have been covered by insurance. So I might be working with the insurance company who's saying, well, actually, technically, you weren't covered by insurance during that accident. And so we don't need to pay you. So that's a really unpleasant side to be on. Jurors can tend to like not react well to that kind of thing.
Yeah.
But what they're looking for is they want to know how that decision was made that the decision was made to not insure. Why? What were the thoughts that linked together? Not just the policy, but a human being making the choices. So I've done those kinds of cases where you humanize, you really put people there with like the insurance adjuster making the decision and going through his or her mind, like this is what they are weighing and why these choices were made. And you'd be amazed at how fast that becomes a story that is engaging and is relatable and is something that is much, much easier to agree with. The jurors can say, oh, I see what the thinking was behind that. Yeah, on a human level, not just following policy, which is very inhuman.
And I can see how important that is, because we've heard stories recently about how algorithms are determining what coverage applies and who's covered and who's not and what procedure and all of that kind of thing. And so that's, it sounds like it's coming from a computer or, like I said, an algorithm rather than a human. So put a face on it.
Yeah. Absolutely put a face on it because they want to. Another thing I think that has changed, you initially said, how are things changed? I think in very recent memory here, people were maybe a little more fair-minded, so
Yeah.
is one way to put it. And now it's kind of like you don't know. Someone might be sitting there in that jury box being like, I just hate doctors. I just hate hospitals or especially insurance companies, or even more generally, I just think that the big corporate machines should just be punished. I just think they should be punished. Now, of course, you've tried to weed them out in jury selection. Of course you have, but you don't necessarily succeed at that always. That you might not quite have gotten to that. And they might just be sitting there with a need to like make their voice heard, punishing the man, so to speak. They're not supposed to be doing that. Of course, they're not, they're supposed to be just weighing the evidence, but they're human beings. So they might be. And that's sort of a little bit, there's a big sort of swell of that going on culturally that is absolutely in the room for these trials.
Yes, these are very polarizing times we're living through. And I just heard something recently where somebody said, it's okay not to have an opinion about that, but that's not where we are right now. We don't have to weigh in with an opinion on everything.
That's a great point. I'm so glad you brought that up because in a stage of training as an artist, I did a little seminar I attended or was a part of a seminar at Lincoln Center, which was just on aesthetic appreciation.
Mm.
And the biggest thing that was taught in this, and this was like for a month, was how to look at something and simply observe it. Simply observe what it is before saying, I like it or I don't like it. Or, it makes me feel or does not make me feel. All of that is getting into subjective opinion territory. It is incredible. And I took this was 25 years ago. And I mean, imagine how much has changed in 25 years,
Yeah.
I think people have a really, really hard time these days just objectively seeing things before adding their opinion. And here in trial, it is exactly what we're trying to do, is we're trying to say, hey, we're just presenting facts. We're just presenting facts. You guys just need to present the facts, while at the same time, we're totally spinning those facts in our direction. But a juror really needs to chill out the part of their brain that wants to have an opinion and just see facts while they're being sort of, bombarded with storytelling the whole time.
Yeah, and just pay attention and notice things. When you were talking about the noticing aesthetic appreciation, it brought to mind the New York Times has this regular feature where they ask you to open a huge image of a painting. Recently, it was the woman in gold. And you're supposed to just look at it for 10 minutes and do absolutely nothing other than look at it. And that helps you build your ability to notice and pay attention and focus and not allow yourself to be distracted.
Yeah.
And come in with judgment.
It's from the point of view then of the lawyer or the storyteller. If you arrange it right, there is a way to just present facts that appears to be just an objective presentation of facts, but have been skillfully and artfully arranged to cause the mind of the viewer to draw a conclusion from those facts. But you want them to feel like they are just observing. So it's that's the sort of the art of the storyteller in court.
So a minute ago, you mentioned that the defense has the burden of going granular. They have this unpleasant task of talking about the detail of events and policies and timelines, and it's kind of the boring stuff, right? It's not fun
Yeah.
to listen to, it's hard to keep track of, but it's the flip side of it is that the plaintiff probably would also like to keep that narrative end of it pretty general. So they want to go in the opposite direction that you
Mhm.
actually need to go to. First of all, why would the plaintiff want to skip over all of those granular details?
They're never gonna actually skip them because they have to present their evidence, but they're wanting the jury, they're usually wanting to kind of like, throw a smoke screen up or something. They're not, I shouldn't say usually, but often that will happen. And so the instinct of defense is to say, okay, hang on a minute now. We got to get serious and we got to get down to brass tacks and we got to look at all this stuff very, very closely. I've even heard defense lawyers in early drafts of openings say things like, ladies and gentlemen, this is actually a very
Ugh.
complicated case. We have to look very, very carefully at the complicated details. Well, as soon as you tell any group of people that, they're like, ugh, I don't want to. So the skill, and this is what I always work on with, I mean, really, a lot of what I do that we call storytelling is
Yeah.
simplification. It's just making it understandable at all is like the first part of storytelling. Then you get to the good part of storytelling. But this is the hard work is, for instance, taking a timeline. I mean, boy, oh boy, do defense lawyers love a good
Mhm.
timeline. So and it'll be like on a PowerPoint slide with such microscopic lettering that you can't expect anyone can even make out what's on this timeline. And they're going to go through it with meticulous detail, and then they're going to have their expert do the same thing. The key to this is to, first of all, of course, simplify what is on that timeline down to the essential pieces. Just tell them just have on the visual what they really need to understand in terms of dates and times. And you can do the rest of it orally over the top. Okay, especially in an opening. Make sure that you're just keeping the visual very, very, very lean. But the kind of other side of this too is that, are you telling a story with this timeline, or are you just going through the timeline? And it's really easy to mistake going through the timeline because it's chronological for a story, because stories are often chronological. You want to be saying that it should be crystal clear the point you're making by going through this timeline. The jury should never be wondering, why are we watching this timeline? Why are we immersed in this thing? They should be always reminded this is the simple story that's being told while I'm going through 18 steps to get there. So there, like, for instance, there might be a case where what's at issue is that a nerve was, the plaintiff is saying a nerve was compressed in a joint to the point where it caused lasting damage to the patient. And you're going to go through all of the visits to the doctor that this patient did to show that there is no evidence that that nerve was ever compressed. Now, but you have to make the point that what we're saying here is there's no way that nerve could have been compressed. And now which is very simple. And now it might take us 10 minutes to show you all of the evidence that shows that one simple thing. But if you never really make that one simple thing clear enough, they're going to be lost in 28 visits to the doctor and like, why are we listening to all this? And that's the risk.
So these kind of eye-glazing details that you have to share with jurors, simplifying them and creating a context for understanding why you are sharing them are very important. Are there any other tactics to be engaging and persuasive?
Oh, there's lots of ways to be engaging and persuasive. Um, like I say, keeping things focused on the simplest version of the story, going back to the thematic phrasing that you've come up with that just keeps it simple in their mind. Some of it can also come down to delivery. So with Nita, often I'm there teaching about delivery. So how you speak can, if you could have a really well worked out story and have everything nice and lean and not too complicated, but everything you're saying is coming across in a monotone like this. There's no expression on your face and all this. Maybe you're not even facing the jury. You're kind of looking at the screen the whole time. And, that's going to kill the engagement for sure. So it's staying alive, putting more energy into it. And I would say this is a kind of a subtle nuance. Often for defense, something really bad happened to somebody, right? It can be a grave injury of some form or other, or even death. And the defense lawyer can inadvertently, if they're not careful, come across as sort of unfeeling. Just kind of like, well, okay, it was, we feel really bad for the death of Mrs. Smith, but we are here to look at the details of who was responsible for her death.
Right.
Like that kind of thing can really be off-putting. So if we don't necessarily need to stand there and apologize, although there are cases where that is appropriate for defense, but it's more that if you're going to say the words, this case, no one is disputing that Mrs. Smith's death is a terrible tragedy. Like if you're going to say those words, you must say them with a heartfelt tone. No one is disputing that Mrs. Smith's death is a terrible tragedy, and the suffering of her family is unimaginable. We are here to look at the difficult challenge of determining what went into causing this terrible tragedy. Getting it so that the tone of voice just shifts enough. This can really draw people in. I mean, I'm not saying I'm necessarily doing it perfectly on this podcast here, but you know what I mean. It can draw people in to trust you. And that is a form of engagement too. Engagement is not always big drama. It can be warmth and sincerity and calm. Can also be a way to draw people in and engage them in what you're saying. Another thing just on tone and pace and stuff is vary the pace. Don't always be speaking at the exact same pace. Slow it down sometimes, speed it up other times. Pause here or don't pause over there. That variety keeps people engaged too. So that stuff is fairly simple to do.
Great. So you mentioned that coming across as unfeeling can be kind of a blind spot for defense. Can you think of any other blind spots or things that you want to watch out for and be mindful of?
I think in addition to that one that is very risky for defense is if somebody has been gravely injured, okay, and maybe the dispute is, call it something like when the brain stem was separated, okay? You don't want to dive right into talking about the brainstem separation right away, even though that might be something that that becomes a very central focus of the case. If you hit that right out of the gate, because this is going to be a central focus of the case, we got to get to this, all you're going to do is keep reinforcing for the jury how awful that is. And so it's a which is, going to help the plaintiff. So it's really a balancing act. Something's important, but you're already desensitized to stuff like that because you've been working on the case for a year and a half, right? 5 years. I mean, it could be whatever it is. You're desensitized to all this and you're eager to just like, hey, let's go. They're not. They just learned about this like 10 minutes ago. You need to give them time to catch up. And I think with a lot of defense cases they're not always medical cases, but they have to do with people being physically injured or physically, injured. I mean, in many ways, you want to be very, very careful how quickly you get into that because it's visceral. It makes people feel things in their body when you're showing them medical charts and veins and nerves and x-rays and stuff. You have to be very careful of that. So that's one blind spot, I think.
Yeah, too much of a shock to the system right away, too.
Yeah. Yeah.
Well, this is really great stuff. And I love that you have come to the podcast responding to what you've been hearing and giving advice to program participants exactly what they need, what they're asking for. I want to talk a little bit about some of the programs that you teach at NITA that actually address these very issues, turning facts into a story and persuasive presence. Do you want to share a little bit about those programs?
Sure. Yeah. Those are both online programs. They are 2 days each, not full days, just 3 hours each day. So 6 hours total for each of those programs. The one that's called Turning Facts into a Story is pretty closely what we've been talking about here. Of course, not always for defense, but it's taking how to take facts and transforming those facts into something that's an engaging, forward-moving narrative. I encourage everyone who takes that course to bring in their own real facts from real cases, so we can
Oh,
actually work on stuff that there is sort of this very, very light NITA case that they can use, but if they bring in their own stuff, I don't care what type of case it is. I don't even care if it's going to trial. This could be something that's a motion, even, this delivered to just at a hearing.
right.
There's always a way to take that complexity and simplify it and make it more compact and more engaging. So that's what that course is.
Yeah. Storytelling is not just for trial.
No, not at all. I mean, when it's trial, it's probably closest to the type of storytelling we think of that has artistic intentions, because it's like a performance almost. But I look at storytelling as being making anything simple and forward moving so it's understandable and relatable. The forward moving piece is important, and that's where it relates to things that are not overtly like a trial story. So I've worked on a million oral arguments with lots of lawyers. You have a list of 4 things that you need to go through in this oral argument. Well, what order are they in? Are they in an order that adds up to something, or are they just in kind of a willy-nilly random order? That right there is an aspect of storytelling that can be worked on. And people, it's amazing how quickly the results come.
And so you can bring that to the workshop and get your advice and run it by other people who are participating. Yep.
That's right. And the other program is more focused on delivery, the things I was saying a few minutes ago about your voice and your pausing and intentions and inflections, and to a little bit lesser degree, the body, because this is an online program. But we do a little bit on that, and gestures and standing and things like that. But we get into how to take what's on the page or even just a bullet point list and make it come alive in the space, so it becomes engaging in that kind of like performance way.
So you can take both of these classes and they kind of play off of one another.
Right. That's right. Mm-hmm.
So you're also a faculty member for the New Orleans trial program, which is coming up in April. And the reason that I wanted to mention that is because if storytelling is kind of your thing, this particular program run by Dominic Gianna, who was the trial consultant for My Cousin Vinny, has a very audience-centered focus. And so it approaches storytelling from the legal and persuasive point of view that you've been talking about, but he also brings in theatrical consultants from Broadway, and he's got a psychologist who comes in and talks about the persuasive science of it too.
That's right. Yes, I've done that program for now. This is going to be the 14th year. So I will kick off the entire program. Well, Dom kicks it off, but I am the first sort of like formal lecture of the course, where I will talk about exactly what we're talking about here. Largely, that one's for my role is largely more on the level of the performance and delivery stuff.
Yeah, so it's a really special program, and I just wanted to mention it because it's the only program where we really pay attention to all of those kinds of things, in addition to the usual advocacy skills, the openings, the closings, direct, cross, all of that. If anyone's interested, I'm going to leave all of these links to the programs in the show notes, and they can check them out.
Yes, I welcome and encourage anyone to come to that program. It's a lot of fun, and being in New Orleans is also a lot of fun.
It really is. Okay, so we've reached the end, which means it's time for me to ask what TV show you've been obsessed with lately. It's my favorite question.
Lately, I don't know if there's a lately one, but I did start watching or watch the whole season of Pluribus, which was a few months ago. That's Vince Gilligan's new thing. He did Breaking Bad and Better Call Saul. That is spectacular. It really is. And it's such an unusual show, and another one, this is from maybe a year or maybe even 2 years ago, Adolescence. Highly recommend this. It's a British show that is about a boy who committed a crime. But what's really awesome about this show is every episode is one continuous take with the camera. They actually it wasn't done by AI. They actually followed the cast around for a full hour, acting this in many different locations and everything. But that creates this like incredible intensity and urgency to it, which I just think it's brilliant. And it really takes good actors to pull something like that off too. One more I wanted to throw in. This is from a few years ago. My son recommended this big Japanese anime series called Attack on Titan. And I said, I'll watch that and tell you what I think. Well, it's 92 episodes long.
Wow.
Now, the episodes are 30 minutes each, but I did watch all 92 episodes of this thing, and I have to say it is an absolute masterpiece. It really, really, truly is. So I highly recommend Attack on Titan.
That sounds like it's good for the airplane.
Right. Long trip.
Yes. All right. Well, David Mann, thank you so much for coming back to the podcast. It's always a pleasure to talk to you.
And likewise.
And like I said, if you would like to work with David, you've got lots of opportunities. So check the show notes for that.
All right. Thank you very much. It was so great to talk to you too, Marcy.
Please be sure to check the show notes for more information about David Mann's persuasive storytelling and performance programs at NITA. They are a great opportunity to work one-on-one with him on your current case. And if you like this episode, why not share it with a work friend, give our LinkedIn podcast post a thumbs up, or leave us a review on Spotify or Apple Podcasts. These quick actions boost our visibility so that other trial lawyers can tune into these conversations. Thanks so much for listening. We will be back again next month with a new episode all about soft skills that trial lawyers need and how to develop them. Until then, we wish you the very best of luck in your depositions, motions, and trials. Happy lawyering! May the Record Reflect is a NITA Studio 71 production. NITA. We are advocacy enhanced, mentorship reimagined. Welcome to the community.